But none of the what he has
No,
pleaded
it
now
was
is
a
part
32
of the,
petition.
Sir?
Basha was a 32 petition.
No, I'm not on that. In the Allahabad High Court, Malad, I was trying to complete the list of dates. Then this matter, Malad, 81 onwards, the act came. Then TMA, 24 years we were granting degrees. Then in 2005, that's the next date, Malad, 2005, Malad, there was a 50% reservation for MD, MS students. That was challenged. That resulted in the Allahabad judgment, where the judge said, Basha has rightly decided, you are covered by Basha. I didn't go into anything else. So that was not strictly Malad before the court. The issue was only 50% reservation of the Muslim.
Basha upholds the 1951
Yes.
and the 65 amendment.
Yes.
Right?
Yes.
The Allahabad High Court sets aside the 1981 amendment on the ground of Basha.
That's correct.
Now, two questions will arise before us. Suppose we hold that we accept your, for the testing the argument.
Yeah.
Suppose we accept your argument and hold that Basha was wrongly decided.
Right.
Basha upheld the 1951 and 1965 amendment.
Correct.
What would be the consequence of our coming to the conclusion that Basha was wrongly decided on the amendments which were in challenge in Basha? Second, if we hold that Basha was wrongly decided, then what would be the impact of that on the Allahabad judgment? The Allahabad judgment dealt with a challenge to the subsequent amendment.
Yes.
Right?
Right.
Now, if Allahabad has relied exclusively on Basha.
Right.
Now,
Correct.
if we come to the conclusion that Basha was wrongly decided,
Correct.
it would immediately impact upon the judgment of the Allahabad High Court.
Correct.
And therefore, the validity
By the other bench.
actually, if Basha is upheld,
Yeah.
then
Then
the validity of the 1981 Act becomes subsidiary.
That's right. That's
Because the 81 Act purports to restore the minority character
Yes.
of the institution.
Yeah.
If it is held not to be a minority institution,
Restore.
right?
Not restore, confers, according to it.
Right.
It was never there, it confers.
That-
Basha says it's not there.
That's
so it
right. But that's why we are dealing with Pasha. That's the whole point. You can't rely on Pasha to decide on the 1981 Act.
So ultimately, our decision on the validity of Basha
Yeah.
would impact upon not just the amendment, but it also has an impact on the Allahabad
Correct.
judgment.
And therefore, Malad, that matter will be decided by another bench. So your lordships are not going to go to all this. Malad.
Mr. Simple, even on, suppose we even,
That's what I was trying to tell him actually.
even if you overrule Basha on the two legal principles on interpretation of establishment and administration,
That's right. But Malad, the 81 Act will come in the meantime, Malad. Correct.
and in case Basha is overruled, then 81 amendment, they may withdraw their appeals. There is nobody.
We don't know what's going to happen, Malad. So litigation is part of the culture of
It's
this.
quite clear, it serves no purpose then.
I
for-
know, Malad. But your lordship knows it, even when in litigation there is no purpose, still there is litigation.
Why?
Only
Your lordship experiences it every day. So, Malad, Dr. Dhawan will live to argue the next case, Malad. So, Malad, these submissions are being only divert the attention of the court to issues that are not before it. Yeah, of course, everything's up.
That 81 amendment be also examined because
No,
they are not severable.
Not in a reference.
They are not comfortable with that amendment.
No, we
defend
are
that
comfortable.
amendment.
It's not referred.
will definitely have a bearing on the Allahabad High Court judgment. Definitely have a bearing. Which
The reference has emanated from that 81.
So to say that that has a direct bearing.
The reference is in that
Decides Basha, completely decides what the Allahabad High Court has decided either.
Not either.
So, if we overrule Basha and say that AMU has a minority status in view of,
Yes. Is not removing the is not a validating act, removing the basis of the Basha.
no difference.
Overturning Basha.
No difference, Mr. Court, no difference at all, because once Basha is declared to be in bad law,
Right.
the position as it was before Basha in law would have to be examined. That's
Right.
it.
But as my
And therefore, 81 amendment the reasoning of the Allahabad High Court that the legislature is directly overruling the High Court no longer remains.
That is the second part. The first part is Allahabad High Court relies on
Actually,
Basha.
that's a place to
Allahabad High Court directly relies on Basha to say what it says. And then in addition says that
Mr. Kaul, Basha denies minority status to AMU.
Right.
The 81 amendment sought to, as a solicitor, I'll put it in from your point of view, the 81 amendment sought to confer the minority status. They say that this was declaratory. We will have to decide that. Now, the fact of the matter is that if we come to the conclusion that Basha was wrongly decided, the immediate impact of that would be that the denial of minority status to AMU was wrong. We don't agree with the reasons on the basis of which Basha denied minority status to AMU.
Right.
In which case, the reason why my brother is putting that to is this. If we overrule Basha, then the only basis for setting aside the 1981 amendment was that Parliament has merely nullified the judgment in Basha without taking away its basis. If we come to the conclusion that Basha was wrongly decided, that ground of challenge with the Allahabad High Court ceases to have any relevance.
But it has a direct impact on the decision.
Undoubtedly, but
All that I said was
the whole postulate of the Allahabad judgment is that Parliament could not have, without taking away the basis of Basha, overruled it by a simple declaration that they did by amending the definition.
Right.
But if we go to the source, which is Basha, and come to the conclusion that Basha was wrongly decided, the basis of the Allahabad judgment itself is taken away.
In fact, I started by saying
That's right.
that what Basha is decided in has a direct impact on the Allahabad High Court judgment.
So ultimately, it all boils down to whether Basha is correct or otherwise.
That's all that I'm saying, brother. That's all that I'm saying.
That's a core issue.
That's the point.
Mr. Kaul said. In the High Court, reliance was squarely placed on the 81 amendment because they had a 2005 decision which was taken after the 81 amendment saying that they are giving reservation. That was the cause of action for the writ petition before the High Court. In the process of defending that decision, square reliance was placed on the 81 amendment. Therefore, the High Court went into it, looked into the factual finding in Basha saying that it is not a minority institution. Now, therefore, today it can't be that much. The telescope is put back as it were straight away to 1967 and then said, decide Basha in a vacuum, whether it's right or wrong. The difficulty is, in the process of doing that, 81 is relied upon, 72 is thought to be relied upon. Please ignore 81 for a minute, brothers. 1972 is thought to be relied upon. 72 is immediately after Basha. So with all this, I would respectfully submit, when there is a reference made, the matter proceeds on the basis that the entire matter is before the court. One more aspect, Lord. Please see the reference order. Reference order, as what rightly fell from my Lord the Chief Justice, does not confine it only to the question of Basha. He talks about the NC-MEI Act of 2006 as amended in 2010. The question is then, will the 7 judges then completely excise from the consideration that act also? Now they are relying on the 2006 Act also as amended in 2010. So these are, in my respectful submission, my lords, issues where it has to be a holistic picture.
We are not concerned directly with 2006 or 2010 Act. That's not the subject matter of Basha. One. Number two, that has not been examined by any 2 judges bench or 3 judges bench.
I follow, my lords, but then in the reference
That's
order.
it. That's it. Now, directly making a reference over here without there being a direct, yes, what does the second order does of Justice Gogoi, Chief Justice Gogoi does is, it just narrates the history, what has happened. The questions which are there are the ones which were already.
No, not necessarily. With respect, my lords,
It will have some bearing. Why Justice Gogoi refers to it, and that is why we started by saying the scope of reference in our own terms. The entire reference, including Justice Gogoi's order, was about conjunctive or disjunctive. Yashpal in the NSC-MI order, because Surikant pointed out yesterday, the issue arose was, is it established or incorporated in the UGC order? Now, there Yashpal answered it by saying it's and. The 2010 amendment, which was brought about later to the NSC-MI Act also, said it's and not all. In that context, Justice Gogoi, while dealing with the history of what has happened since right from the beginning, the only issue, for 50 years, no decision ever questioned Basha's decision on the individual finding on administrative or establishment. The only question which is being raised repeatedly, like Manya downwards is establish and incorporate disjunctive or conjunctive. And I've shown that in my third comes my notes. That's why this Gogoi, in the reference order of 2019, categorically relies on Yashpal to say that Yashpal, NSC, NCMI, and UGC dealing with the issue of or versus and, not on the issue of my AMU being a minority as administered or established,
Mr. Cole.
only on the adjunctive and conjunctive issue.
Mr. Cole, the principles laid down in YESPAL will definitely have to be referred to while examining Basha. One. Two, the subsequent amendment which has direct bearing, that is 1981 amendment, say, put it otherwise. I think you can reformulate what you are probably trying to say. If the 1981 amendment is approved by the 7th judge bench, is upheld by the 7th bench, then challenge to Basha becomes academic.
I bow down, my lords.
Then Basha, then examination of Basha also does not survive.
Grateful. But all that I am saying is this whole reference
Probably
to
this is what
UGC,
the issue
NSC,
arise.
NCMEI,
From that angle,
Yashpal
Mr. Sibbal,
was not
I'm
nothing in
sorry.
Justice Gogoi's order.
I'll answer that
It was all
straight away.
dealing with adjunctive versus
Alex,
conjunctive.
Let's hear Mr. Sibbal now. We have to wrap up.
Yeah, so we have, because all this time has been.
Only one line, if your lordship.
Now, let's complete Mr. Sibbal's argument. He's almost.
I'll answer it straight away, Madam.
Yeah.
Assuming for the moment your lordship decides that Basha is wrongly decided. Let's assume, Madam. What is the consequence? That I was a minority institution at the inception.
that may not expressly or impliedly approve the 1981 amendment.
Forget 1981, Madam. Your lordships will give a declaration that I am a minority institution. That's all. Forget the 81 Act. What is it? Your lordships can't change the nature of the minority institution if you say that Basha is wrongly decided. That nature will not change, Madam, under the 1981 Act. 1981 confers something, what your lordships would already have decided. What are we talking about? So let's be clear on what the lay of the land is. If Basha is rightly decided, then the question arises whether the 1981 Act.
Whether did it take away its basis or merely nullify the judgment?
Exactly. Then only it arises, not otherwise.